Yes.
My lord, my lady, I appear with Mr. Bedden and King's Counsel for the appellant, Impact Contracting Solutions Ltd, and my line of friends, Mr. Watkins and Mr. Carey, appear for the respondent commissioners. In terms of housekeeping, you should have one core bundle and 2 volumes of authorities that
Yes.
should have been supplemented over the last few days with an additional authority, Cityland, from us, and an additional statutory provision from the commissioners, together with an updated index.
Where did those go?
They are
The end of
the
volume
very
2?
end, tabs 38 and 39 of volume 2.
38.
38 should be
Cityland.
Cityland.
Yep.
And then they should have paragraph 2 of Schedule 41
Yes.
of the Finance Act 2000.
You all got that? Yep. Yep, I think we have those.
In terms of housekeeping, I had one other indulgence to seek, and it relates to the heat. I'm not at this stage going to ask to dispense with any items of clothing.
Right.
But if we could perhaps have a mid-session break
Sure.
this morning and this afternoon, so that one can rehydrate.
Yes. Yeah, sure. 12 o'clock or something like that. Can you tell me about timing? How long have you divided the time between you?
Well, I'm hoping that my line of friends are going to get on well before the short adjournment.
Good.
Obviously, that depends on how interactive this process
Yes.
turns out to be.
Yes.
But I'm hoping that I'll be able to sit down by 12:30.
Right. Thank you.
So our appeal is against a decision of the Upper Tribunal released on the 1st of September 2023, and as you have seen, permission was granted by my lady on 2 grounds, but at its core, the appeal raises the question of whether the power to remove an existing VAT registration from a taxable person on the basis identified by the Court of Justice in Ablesio, pursuant in other words to what I'll call the Ablesio principle, is available only where that taxable person has fraudulently used his VAT registration number to commit fraud, or whether the Ablesio principle also permits the deregistration of a taxable person who hasn't committed VAT fraud, but who enters into transactions which are connected with a VAT fraud perpetrated by someone else, which that taxable person knew or should have known about.
Can we just make sure we understand exactly how you're putting that? Using your own VAT number to commit fraud, do you confine that to a case where VAT fraud is committed by the taxable person in the sense of them failing to account for VAT or them fraudulently reclaiming VAT?
That's certainly my primary case, yes. It's fraud by that taxable person.
Well,
that's not what you said. The way that the preliminary issues are formulated, which we've got at paragraph 3, draws a distinction as to whether Ablesio applies only to a party that has itself fraudulently defaulted on its VAT obligations, or whether it similarly applies to a party who's facilitated that fraud of another party. Now, what is your answer to that preliminary issue, question 1? That it's the former.
That it's the former.
Without qualification.
Without qualification.
And that's and so far as question 2 is concerned, do you take issue with the what was held by the FTT and the Upper Tribunal that know or should have known is sufficient? If you're wrong on the first question.
Yes, we say that the Kittle approach of knew or shouldn't known doesn't come within the scope of the Ablesio principle.
Can we just look at the preliminary issue questions? Because as I understand it, this is an appeal from determination of what the answer is on those preliminary issues. And on question 1, I think you've confirmed, your answer to question 1 is it's the former. Ablesio only applies if it's a default on its own VAT obligations. And then question 2 is if you're wrong about that, and it can extend to facilitating VAT fraud of another party in the sense of fraud by evading that person's VAT obligations, must you additionally prove A, dishonesty, or B, knew, facilitating, or C, should have known that it was facilitating? What's your answer to that?
Should have known doesn't come within Ablesio. Knew or committed fraud itself does come within the principle.
Sorry, which of A, B, and C do you say is the right answer? That's
Sorry,
the question.
I'm trying
Have
to
you got
find
the
where
questions
the
there?
formulation of the questions is, because I'm looking, I think, at a different document.
So paragraph 3
Upper Tribunal, page 85.
85 of the bundle, paragraph 3 of the Upper Tribunal decision.
So we say, in relation to question 2, that either the facilitating party was itself dishonest, that's within Ablesio, or that it knew that it was facilitating the fraud, that's within Ablesio, but should have known is not within Ablesio.
So A or B will do.
But not C. Sorry, as Mr. Bedman reminds me, that of course is our fallback position, because our primary position is that it's got to be
Exactly.
the party which
No, I
himself
understand that.
fraudulent-
Question
Yeah.
2 only arises if you're wrong on question 1.
Exactly.
Yeah.
But can we then just go back to question 1 and to the original question, I think, which is, are you putting the case any differently to the way that question 1 is posed? So in other words, by committing fraud, do you confine that to a situation where the taxable person has fraudulently defaulted on its own VAT obligations?
On question 1, yes.
And then, so that is how we should understand the way you put your case right when you opened it.
Yeah, that's our primary position. That
The
it's
reason I
fraudulent
ask is
defaulted.
because you use the expression fraudulent use of your own VAT registration. But on one understanding of that concept, you could, if you know that you're party to a fraudulent chain, even though the VAT default is happening at some other part of the chain, it would still be possible to describe that as fraudulently using your own VAT registration. However, I understand you not to be saying that. You're making a point that it actually has to be your own VAT default.
Our primary position is it's the fraudulent defaulter himself. Our secondary position would be someone who knew that they were facilitating a fraud is within Ablesio, but not someone who should have known.
Thank you.
And stage 2 knew that he was facilitating a fraud connotes dishonesty, just as fraudulent default involving dishonesty.
So it's A and B, not A or B. Is it? I've written down you said A or B.
So A and B.
It's A and B. So your primary position is, if party A sets up a scheme whose sole purpose is to enable party B, which party A controls, to default on its, i.e. party B's, VAT obligations, and that would amount to a civil and criminal conspiracy to defraud the revenue in English law, leave aside European VAT law. Nevertheless, there's no power to refuse to register. If a person says that's what I intend to do, the party A says that's what I intend to do, no power to refuse to register because the default will be on party B's obligations, not party A. That's your case.
That's our primary position. One can see that one might then quite quickly find oneself debating our secondary position in relation to what's involved in what's meant by fraudulently making use of a VAT registration.
Okay, thank you. Yes.
So the Upper Tribunal's key findings were these. First of all, it held in paragraph 100A to B that the Ablesio principle does extend so far as to permit commissioners to deregister or refuse to register for VAT a taxable person who hasn't himself fraudulently evaded VAT or had any intention of doing so, but who's purchased goods or services from transaction chains in which someone else has fraudulently evaded VAT, where he knew or should have known of fraudulent evasion by that other person. And secondly, it held in paragraph 100C that the Ablesio principle permits the VAT deregistration of such a person, notwithstanding that he's also made or is also making taxable supplies which are unconnected with fraud, the consequence of which on the face of it is under paragraph 1.1 of Schedule 1 to the VAT Act that he's required to be registered for VAT. Thirdly, it held in paragraph 111 that the use of the Ablesio principle to deregister a person who's merely facilitated fraud of another and who's also made untainted supplies doesn't, in and of itself, systematically undermine the right to deduct input VAT. And fourthly, it held in paragraph 118 that the deregistration pursuant or purportedly pursuant to the Ablesio principle of someone who's merely facilitated fraud of another and who's also made untainted supplies doesn't contravene EU law principles of fiscal neutrality, legal certainty and proportionality. We respectfully submit that the Upper Tribunal fell into error in two key respects. First, in holding that the Ablesio principle permits the deregistration of a person who hasn't himself fraudulently evaded VAT or had any intention of doing so. And secondly, in failing to recognise that the extension of the Ablesio principle in this way, and we say it does represent an extension of what the Court of Justice held in Ablesio itself, systematically undermines the right to deduct and breaches those EU law principles. What I intend to do, subject, of course, to your lordships and your ladyship, is first of all to ask your lordships and your ladyship to take a brief look at some of the provisions which make up the relevant statutory framework, before turning briefly to some of the principles set out in the authorities, including Ablesio itself, and then to consider what we respectfully suggest are the errors in the Upper Tribunal's approach, and I'll try at the same time to respond to certain submissions made on behalf of the commissioners in their skeleton. But before doing that, I'd like to make a couple of preliminary overarching remarks. First, it's our case that properly understood deregistration under the Ablesio principle really is the nuclear weapon in HMRC's arsenal. I'm conscious that my Lord Justice Popplewell and my lady have heard me describe something else in a quite different context not very long ago as a nuclear weapon, a submission which I didn't think found very much favour with Lord Justice Popplewell.
There are different kinds of nuclear weapons.
There
you
are-
need to worry about.
There are different kinds of nuclear weapon, and we say that here the description, whilst perhaps unimaginative, is apt. We say that it's properly targeted, deregistration under Ablesio, at traders who've themselves committed fraud by fraudulent misuse of their VAT registration numbers, and that the Upper Tribunal was wrong in our respectful submission to hope it goes beyond that and catches traders who haven't acted fraudulently or intended to do so. The more limited interpretation of the Ablesio principle for which we contend is, we say, supported by what was actually said by the Court of Justice in Ablesio itself, which in our submission not only makes clear that this weapon is targeted only at those who act fraudulently, but also repeatedly warns that any steps which member states take shouldn't systematically undermine the right to deduct. And we say that's exactly what deregistering a non-fraudulent trader does, We also submit that our less expansive interpretation of Ablesio is supported by general principles of EU law.
But again, you're using fraudulent and non-fraudulent in this submission, are you? To note the distinction that is in preliminary issue 1, that is to say, fraudulent in relation to its own
to its own transaction.
So it doesn't apply to those who are fraudulent in the sense of conspiring to defraud by party B.
Not on our primary submission, no. Secondly, we'd ask rhetorically how deregistering someone who's undertaking untainted transactions to an extent which exceeds the compulsory VAT registration threshold can be reconciled with the statutory obligation for that person to be registered for VAT and with the requirement under EU law to avoid systematically undermining the right to deduct. And you may recall from our forgive me.
I'm sorry to keep interrupting, but how does the question of whether there are or aren't any untainted supplies fit into your answer to preliminary issue 1, which I thought was an unqualified one?
Well, in terms of what we say on ground 2 in relation to legal certainty, we say that what we've referred to as a conundrum faced by businesses who are making untainted supplies in excess of the compulsory VAT registration threshold. And the fact that it is very far from clear, even on the Commissioner's case now, what the position is of such a trader. That's, we say, highly material to ground 2 in relation to the contravention of legal certainty.
Forgive me, I don't understand that. Questions, the preliminary issues are framed in general terms, that is to say, can the Ablesio principle apply? And if it applies, can it be sufficient that those are the mental elements? And that doesn't address whether that can only be the case if there are also untainted supplies. It's just a general question. Do you answer the question differently if there are untainted supplies?
Well, if there are untainted supplies, then the points we make in relation to ground 2 and legal certainty are engaged. If they're not making untainted supplies, then the conundrum that we've referred to doesn't arise.
This is effectively going back to the preliminary issues, and this is a fallback, obviously. That would be a qualified answer to question 1 in the preliminary issues.
Yes.
In other words, your primary case is an unqualified answer to question 1.
Already, yes.
And the fallback is qualified.
Is that right? So,
Yes,
your answer to question 1 is a primary case can never apply where it's not evasion of the registered person's own VAT obligations. Alternative is it can apply if there are no other untainted services, but it can't apply if there are some other untainted services. Is that, have I understood
Well,
you? Have I understood you?
I think that is what
you're saying?
I think that is what I've said.
Yeah.
And the position is
what you want to say.
Well, the position is slightly more nuanced because the issue of legal certainty and indeed the uncertainty which will apply to a trader deregistered under the Ablesio principle in terms of prospectively making untainted supplies which exceed the compulsory registration threshold. And that uncertainty will exist whether he has historically or is currently making supplies. But the question is what's he going to do? So I think the position is probably more nuanced than I had said, in the sense that the uncertainty, which we say contravenes the principle of legal certainty, will apply, but one sees its effect in the case of someone who is in fact trading above the compulsory registration
Well,
threshold.
the CJEU must have recognised some, or did recognise some impact on legal certainty, because Ablesio, on its terms, doesn't say, well, you must still register if there are going to be some untainted supplies. It countenanced a refusal to register. And I don't understand you, but correct me if I'm wrong, I don't understand you to be saying that Ablesio can never extend to deregistration.
No, we don't say that Ablesio, but the Ablesio principle permitting the deregistration of traders doesn't exist at all,
Right.
clearly.
So there clearly is some issue of legal certainty anyway, isn't there? Because if you like, on the facts of Ablesio, although I know it went back to the National Court, so it's hard to talk about facts, but in principle, member states are permitted not to register an entity that might otherwise, or possibly deregister an entity that might otherwise be making taxable supplies above any relevant threshold. So there is some issue of legal certainty. It's a question of extent, isn't it?
But that question is one which we say is particularly acute in the case of a trader who is trading above the compulsory registration threshold, and it's,
I don't understand that, because even in cases of deregistration, its effect is for the future, not for the past. That's Kittle. So, in just the same way as the Ablesio principle, strictly speaking, applies to refusal to register on grounds that, I've forgotten what the phrase is, but there's cogent reason to believe, or something like that, that the conditions will be fulfilled. That, of course, involves, as my lady says, an element of uncertainty about whether that would or wouldn't take place. If you apply Ablesio to permitting deregistration in the same circumstances as would justify non-registration, then the past conduct in having untainted supplies doesn't give you the answer, does it?
no, because it has to be prospective.
It has to be prospective. So that the level of uncertainty is the same, isn't it?
Well, one might wonder whether in practice it would be by comparison with a trader who hasn't been trading and is seeking initial registration. I mean, that's which was the situation of Ablesio.
That all depends on the evidence in the particular case, which isn't what we're concerned with when we're dealing with matters of principle.
Could we look, I hope very, very briefly, at the relevant statutory
Yes.
provisions? There are two ways of doing this. I mean, I can ask you to go to the authorities bundle. Many of these provisions are also set out in the Upper Tribunal's decision. So perhaps
Whichever you think is easier.
I can give you both lots of references if
Okay.
that helps. So the recital 7 to the Principal VAT Directive is at Authorities Bundle 1, tab 17, page 45, and in paragraphs 11 to 14 of the Upper Tribunal's decision, Core Bundle 887. The common system of VAT should, even if rates and exemptions are not fully harmonised, result in neutrality in competition, such that within the territory of each member state, similar goods and services bear the same tax burden, whatever the length of the production and distribution chain. Article 9, which is referred to in the Upper Tribunal's decision, paragraph 11, it's in the authority bundle at volume 1, tab 18, page 46. Article 9 defines taxable person economic activity as follows. Taxable person shall mean any person who independently carries out in any place any economic activity, whatever the purpose or results of that activity. Any activity that produces, traders or persons supplying services, including mining and agricultural activities and activities in the professions regarded as economic activity. Article 213, it's at volume 1, tab 19, page 47, referred to by the Upper Tribunal at paragraph 12, provides that every taxable person shall state when his activity as a taxable person commences, changes, or ceases. And Article 214, volume 1, tab 20, pages 47 and 48, referred to by the Upper Tribunal at 13, deals with the provision of a VAT number as follows. 1. Member States shall take the measures necessary to ensure that the following persons are identified by means of an individual number. A. Every taxable person, with the exception of those referred to in Article 9.2, who within their respective territory carries out supplies of goods or services in respect of which VAT is deductible, other than supplies of goods or services in respect of which VAT is payable solely by the customer or the person for whom the goods or services are intended in accordance with Articles 194 to 197 and Article 199. And then Article 273, Authority Funding 1, tab 21, page 49, referred to by the Upper Tribunal at 14, confers the following powers on Member States. It says they may impose obligations which they deem necessary to ensure the correct collection of VAT and to prevent evasion, subject to the requirement of equal treatment as between domestic transactions and transactions carried out between Member States by taxable persons, and provided that such obligations do not, in trade between Member States, give rise to formalities connected with the crossing of frontiers. Turning now to the domestic legislation, Section 3.1 of the VAT Act, Core Bundle, Volume 1, Tab 3, page 11, referred to by the Upper Tribunal, paragraph 15, provides that a person is a taxable person for the purposes of this Act while he is or is required to be registered under this Act. Section 4.2, Volume 1, Tab 4, page 13, referred to by the Upper Tribunal at paragraph 16, defines a taxable supply as a supply of goods or services made in the United Kingdom other than an exempt supply. And then paragraph 1 of Schedule 1 to the Act provides that persons making taxable supplies are liable to register for VAT if the value of their taxable supplies in the preceding 12 months is exceeded or is expected in the next 30 days to exceed £85,000, which I'll call the compulsory registration threshold. That's at volume 1, tab 7, page 21, and was referred to by the Upper Tribunal at 17. Paragraph 5.1 of Schedule 1 provides that where a person, this is volume 1, tab 8, page 25, referred to by the Upper Tribunal at 18, where a person has exceeded the compulsory registration threshold and therefore become liable to register for VAT, they must notify HMRC of his liability to register. And then paragraph 5.2, this is on the same page, referred to again by the Upper Tribunal in paragraph 18, provides that where a person has exceeded the compulsory registration threshold, the Commissioners shall register any such person, whether or not so notifies them, with effect from the end of the month following the relevant month, or from such earlier date as may be agreed between them and him. Paragraph 9 of Schedule 1, this is at tab 9 of Volume 1, page 27, provides that where a person making taxable supplies or carrying on a business and intending to make taxable supplies satisfies HMRC of the same, they shall, if he so requests, register him. And then paragraph 13, which is at volume 1, tab 10, page 29, referred to by the Upper Tribunal in paragraphs 19 and 54. Paragraph 13.2 provide that subject to subparagraph 5 below, where the Commissioners are satisfied that a registered person has ceased to be registrable, they may cancel his registration with effect from the day on which he so ceased, or from such later date as may be agreed between them and him. And subparagraph 5 provides that the Commissioners shall not, under subparagraph 2 above, cancel a person's registration with effect from any time, unless they're satisfied that it's not a time when that person will be subject to a requirement or entitled to be registered under this Act. And registrable, as one sees from the Upper Tribunal's decision of footnote 3, page 88 of the Core Bundle, registrable under paragraph 18 of Schedule 1 means liable or entitled to be registered under Schedule 1. I can deal, I hope, fairly shortly with what we say are the relevant principles of EU law. We've already seen what recital 7 to the Principal VAT Directive says. If one, then I think the easiest way of doing this is to look at our skeleton, paragraph 35. So that's core bundle, tab 3, page 24. There we refer to case GST Starvins, top of page 24, AG Germania. Paragraph 32 of the Court of Justice's decision. It should first of all be borne in mind that the court has repeatedly held that the principle of the neutrality of VAT manifests itself through the deduction system, which is meant to relieve the taxable person entirely of the burden of the VAT payable or paid in the course of all his economic activities. The common system of VAT therefore ensures that all economic activities, whatever their purpose or results, provided that they are in principle subject to VAT, themselves subject to VAT, are taxed in a neutral way. And then paragraph 34 of the same decision, it should be borne in mind that the measures which the member state may adopt in order to ensure the correct levying and collection of the tax and for the prevention of fraud must not go further than is necessary to attain such objectives. They may not therefore be used in such a way that they have the effect of undermining the neutrality of VAT, which is a fundamental principle of the common system of VAT established by the relevant EU law. Then moving on to the right to deduct, on the same page, page 24 of our skeleton, we refer to the Gavel-Friese case, where the Court of Justice held that the deduction system was meant to relieve the trader entirely of the burden of the VAT payable or paid in the course of all his economic activities. The common system of VAT consequently ensures that all economic activities, whatever their purpose or results, provided that they're themselves subject to VAT, are taxed in a wholly neutral way. And then over the page, at the top of page 25 of our skeleton, we refer to Kittle at 47. We refer to Kittle at 47, which talks about the right to deduct being an integral part of the VAT scheme, which in principle may not be limited, and being exercisable immediately in respect of all the taxes charged on transactions relating to inputs. That, of course, is subject to what's then said in Kittle at 61, which is also referred to in paragraph 37 of our skeleton, that where it's ascertained having regard to objective factors, this applies to a taxable person who knew or should have known that by his purchase he was participating in a transaction connected with fraudulent evasion of VAT. It's for the National Court to refuse that taxable person entitlement to the right to deduct. And we make the point a little later on in our skeleton at page 28 of the bundle, paragraph 48, that the Upper Tribunal talks about the abuse of law principle in the VAT context being wide, which we say is correct so far as it goes, but that it doesn't properly reflect the fact that abuse isn't a one-size-fits-all concept, and that what constitutes an appropriate step to combat the alleged abuse will depend on the nature of the abuse in question, taking into account principles such as the principle of fiscal neutrality, which is subject to the common system of VAT, and I'll come back to that briefly in due course. Turning then to the Court of Justice's decision in Ablesio, that was, of course, concerned with a refusal to register on the grounds that Ablesio didn't have the material, technical and financial capacity to carry out the declared economic activity, on the basis it had no fixed assets, no agreement had been concluded to lease such assets, an occupational lease had been concluded to rent an office with only a small non-residential area. The company wasn't registered in the Register of Construction Companies, hadn't carried out any actual commercial activities since its establishment, and its only employee was the apparently unlimited chairman of the board. And then the District Administrative Court held that the requisite information had been provided, the accuracy of which wasn't contested. That was upheld by the Regional Administrative Court, and then the Tax Authority appealed against that decision on a point of law, and it was in that context that the questions were referred to the Court of Justice for a preliminary ruling. And moving on to what was decided in that case, Authorities Bundle Volume 2, tab 33, page 303.
Am I right that the only information we have as to what might be described as the business model that we're concerned with is in the letter of the revenue? Is there any other sort of information as to the precise way in which the business was operated?
I think we say something in our skeleton about the mini umbrella company.
Could you just
business
very
model.
briefly sort of elaborate on how the structure operates?
Yeah. So the appellant impact operators, this is paragraph 7 of our skeleton, page 18 of the core bundle. It was a contracting intermediary
Yes.
supplying labour to temporary work agencies and to a lesser extent directly to end users.
Yes.
About 81% of the labour supplied in the relevant period was purchased from so-called mini umbrella companies, and the remaining labour wasn't. So it's a contracting intermediary.
And those mini umbrella companies would have a number of people to whom who have a contracts with them, or how do they operate?
So, in very general terms,
Yes.
they have a small number of employees.
Yes.
Each, and they might supply labour to a small number of intermediary companies like Impact.
Right.
I don't think there is anything else very much in the
No,
materials
okay.
before the court in relation to the business model. But I hope that
Thank
gives
you.
a flavour at least. Sorry, page 383 of Authorities Bundle 2, paragraph 28 of Ablesio. According to settled case law of the court, member states have a legitimate interest in taking appropriate steps to protect their financial interests, and prevention of tax evasion, avoidance, and abuse is an objective recognised and encouraged by Directive 2006/112, the Principal VAT Directive. There's a reference to Halifax and a case called Mednis. A little further down in paragraph 30, member states can legitimately take measures that are necessary to prevent the misuse of identification numbers, in particular by undertakings whose activity and consequently their status as taxable persons is purely fictitious. But those measures mustn't go beyond what's necessary for the correct collection of the tax and the prevention of evasion, and they mustn't systematically undermine the right to deduct VAT and hence the neutrality of that tax. Just pausing there, if one looks at what the Upper Tribunal said in paragraphs 34 to 36 of its decision, so that's core bundle tab 8, page 93. Second sentence of paragraph 34, tax authorities, this is referring back to Ablesio, could not refuse to register a person for VAT solely on the grounds relied on by the Latvian authority. However, it was legitimate to refuse registration where a risk of abuse existed.
So it's my fault. Where are you now?
Sorry, page 93 of tab 8 of the core bundle, paragraph 34 of the Upper Tribunal decision. Legitimate to refuse registration where a risk of abuse existed within limits, and then refers to Ablesio at paragraphs 28 to 30, which we just looked at. And then at paragraph 35 over the page, it cites Ablesio at 34 and 38. In order to be considered proportionate to the objective of preventing evasion, a refusal to identify a taxable person by an individual number must be based on sound evidence giving objective grounds for considering that it is probable that the VAT identification number assigned to that taxable person will be used fraudulently, such as written over an assessment of circumstances and the evidence. And in paragraph 38 referred to there, it's for the referring court to examine whether, having regard to all the circumstances of the case, the tax authorities established to the requisite legal standard the existence of sound evidence from which it may be concluded that the application of registration in the register of taxable persons subject to VAT by Ablesio might result in the misuse of the identification number or other VAT fraud. So we say, just pausing there, deregistration might therefore be an appropriate step or measure, we say, in certain specific circumstances. So you've got paragraph 34 of Ablesio, where it's probable that the VAT identification number assigned to that taxable person would be used fraudulently. And paragraph 36 of Ablesio, referred to by the Upper Tribunal, forgive me, back in volume 2 of the Authorities Manual 384, paragraph 36 refers to circumstances of the nature which obtained in that case corroborated by the presence of other objective elements leading to the suspicion of the taxable person's fraudulent intentions may constitute factors that have to be taken into account as part of the overall assessment of the risk of evasion. So the taxable person's fraudulent intentions.
Is it your submission that this authority is referring to fraudulent intentions or fraudulent use in the narrow sense in which it's used in the preliminary issue ground 1, so that it couldn't extend to the example I give of misuse for the assistance of fraud by B?
I think that's our primary position. Our secondary position would be that fraudulent intentions.
What would be the logic of that? If the number is being used as part of a fraudulent conspiracy by A, that B should evade that. Why should that be outside the principle when it's inside the principle? It's the evasion by party A.
Well, my
So
lord,
what's the logic in that?
My lord, I accept that on the face of it, the reference to fraudulent intentions itself would cover the situation where A is controlling B, as you posited earlier.
Not necessarily controlling, but party to a conspiracy.
Or party to a conspiracy.
If we look at some of the language that you draw attention to in paragraph 30, it says that states can take measures that are necessary to prevent the misuse of identification numbers, and then it gives in particular. But that's quite a general. That's broadly phrased. Necessary to prevent the misuse of identification numbers.
My lord, yes. I mean, the fact that they then go on to refer in particular, they say by undertaking such activity and consequently their status as taxable persons is purely fictitious. That's a pointer, we respectfully suggest, to the kind of misuse being referred to there, being fraudulent misuse. Incidentally, the Upper Tribunal seems to have got the impression that that our case was that it's only in circumstances where the activity is fictitious that this applies. That certainly wasn't our
No, I understand. You relied on the, but as the Upper Tribunal pointed out, the use of the expression in particular might suggest the other way. That's just in particular an example of when it might be legitimate to take measures to prevent. I'm really focusing on to prevent the misuse of identification numbers. It's not saying the misuse by a taxable person of their directly identification number in the terms of the first part of issue 1.
Well, if one looks, for example, at paragraph 39,
Yes.
again, there's a reference there to sound evidence leading to the suspicion that the VAT identification number assigned will be used fraudulently. That again seems in our respectful submission to point to what the Court of Justice was identifying as the principle in play there, or the exercise that needs to be engaged in.
The Upper Tribunal you took us to referred to paragraph 38. And I don't know whether are you coming to paragraph 38 or have you dealt with paragraph 38? Because that does say in the last sentence, might result in the misuse of the identification number or other VAT fraud.
And my lord, our position as set out in the skeleton is that also points to the nature of the misuse that's being referred to being fraudulent. Otherwise, it would have said misuse or VAT fraud, as opposed to misuse or other VAT fraud.
Sorry, could you say that again?
The reference there to or other VAT fraud
Yes.
it explains what was meant by misuse of the identification number and shows that the misuse of the identification number being referred to there was fraudulent misuse. Otherwise, it could and presumably would have said the misuse of the identification number or VAT fraud as opposed to or other VAT fraud.
I see. So
it only makes sense if the misuse is itself fraudulent.
So what? Just you're saying the or other VAT is explaining the misuse of the identification number, which is being referred to earlier. It's not an expansion of.
Or other VAT fraud shows that the misuse that was being referred to was fraudulent misuse.
Okay.
Otherwise, other doesn't really make sense.
Thank you.
And you contend that fraudulent misuse means that the VAT number, that the person with the VAT number is itself evading VAT.
My lady, yes. As I've said, our primary position is it's fraudulent evasion, fraudulent default by that taxable person. Our secondary position would be that, in for example, the scenario posited by my Lord Justice Popplewell, that would also be within the scope of the brief. I get to mention, sort of slightly going off at a tangent now, but it's quite an important point. We've referred in paragraph 17 of our skeleton, and the revenue is referred in paragraph 11 of their skeleton to the case of Citibank. And what we rely on is the fact that in that case, it was held whilst the revenue can of course allege that the taxpayer has acted dishonestly and fraudulently in relation to the transactions.
Sorry, we finished with Ablesio, have we?
We've finished with well, we're coming back to Ablesio in a moment.
Okay.
So in terms of document management, it might help to keep it available.
Okay.
Sorry, essentially what was held in Citibank was that while in the context of Kittle, HMRC can of course allege that a taxpayer has acted dishonestly and fraudulently in relation to the transactions to which it was a party. They do not need to do so in order to deny that taxpayer the right to reclaim input tax under the Kittle test. And so the way we put it in our skeleton, paragraph 17, so that's core bundle page 20, is that it's well established that a plea limited to an allegation that a taxable person knew or should have known that its purchases were connected with fraudulent evasion of VAT is not an allegation of fraud, or to use the other expression used in Ablesio, paragraph 36, fraudulent intentions as against that taxable person. And the commissioners in paragraph 11 of their skeleton also make the point to refuse the right to deduct input tax based on Kittle, so knew or should have known, doesn't require proof of dishonesty or fraud by the taxpayer whose right to deduct is refused. In terms of Ablesio, we've already looked at paragraph 38, and we've touched on paragraph 39, but perhaps looking at paragraph 39 on page 384 in slightly more detail will be helpful. There we have the reference to the VAT number assigned being used fraudulently. So again, we say this points to the conduct and state of mind which engage the Ablesio principle being necessarily fraudulent. If we could now please look at the Promexor case, that's at tab 36 of volume 2 of the authorities bundle. At paragraph 41 on page 470, where the Court of Justice refers twice to Ablesio. It says, although it follows from the wording of Article 214 of the VAT Directive, that member states have a certain discretion when they adopt measures to ensure the identification of taxable persons for the purposes of VAT. That discretion cannot be unrestricted, so that a member state cannot refuse to assign an individual number to a taxable person without legitimate grounds. And just pausing there for a moment, you may recall in our skeleton, page 11, footnote 5, we explained that the language of the case was remained, and there seems to be a translation error in the second sentence of this passage in the English version, which suggested that the sense is clear from the French version.
This is a post-EU exit case, is it?
It's from 2021, I think. So it's after 31st of December
Yes.
2020. Yes.
Just to be
So
clear
it's
about
something to which this court can have regard. And the same, of course, is true of the recent Cityland decision, which was
Sorry,
only
the same is true of the.
So Cityland, the case that found its way
Oh, yes.
into the bundle this week, that was only decided, I think, at the start of April. So it has the same status as something to which this court can have regard. As I was saying, it's slightly awkward. We have only very recently written to those instructing my learned friends, seeing whether they agree our translation. And I don't think we've heard back from them. But we say that what, as is clear from the French version, what paragraph 41 then goes on to say is that in particular, if member states, or although member states have a legitimate interest in taking appropriate measures to protect their financial interests and combat fraud, tax evasion and possible abuse, if they can therefore just as legitimately provide, in accordance with Article 273, first paragraph of the VAT Directive, measures capable of preventing the misuse of identification numbers, in particular by companies whose activity and consequently whose status as a taxable person would be purely fictitious, these measures mustn't go beyond what's necessary to ensure the adequate collection of the tax and avoid fraud, and they must not systematically call into question the right to deduct VAT and therefore the neutrality of
Just to be
that
clear,
tax.
where you say the translation error is, you say it's
Well, the second sentence
that the
doesn't.
prevention.
After that, it seems to go awry.
Okay.
We've
The expression tax evasion, avoidance and abuse, you say, is potential mistranslation.
No, it's not that. It's the fact that the sentence doesn't hang together. There's something missing. But the actual sense, we say, is clear from the French version. I don't take issue with the reference to the prevention of tax evasion, avoidance and abuse.
That comes straight from paragraph 28 of Ablesio.
Exactly. So that's not the problem. It's just that the sentence doesn't really hang together.
But it's the word that shouldn't be there, is it? Just interest in one, taking appropriate steps to protect their financial interests. Two, the prevention of tax evasion, avoidance and abuse.
Sorry, forgive me. I think that works. Yes. But anyway, it's what we rely on is the fact that again, by reference to Ablesio, there's a reference to in particular undertakings whose activity and consequently their status as taxable persons is purely fictitious. And again,
Sorry, it's my fault. How does the French version help us with that?
I think it may be if one takes out the that it works, but it doesn't work with the that. The English version. I'm not sure there's likely to be anything between this in relation to what this is actually getting at, not least because it's taken from Ablesio. But again, there's a reference to not going beyond what's necessary for the correct collect of the tax and prevention of evasion, and those measures mustn't systematically undermine the right to deduct.
Well, that's the critical part, and you don't object to the translation in relation to that.
No.
So it's wider than just tax evasion, it's tax avoidance and it's abuse.
Well, those, what that records is that member states have a legitimate interest in taking steps to prevent those things. I'm not sure that that answers the question of what an appropriate step is in.
But put it another way, I don't really understand you to contend that this paragraph takes matters any further. It's consistent with the earlier cases.
That's it's
breaking new ground.
No,
These are common.
It just repeats what's in paragraph 28 of Ablesio. In terms, member states have a legitimate interest in taking appropriate steps. I'm reading paragraph 28 of Ablesio. To protect their financial interests and the prevention of tax evasions, avoidance and abuse is an objective recognised and encouraged by the directive, see in particular Halifax and Netherlands. I read that earlier.
It restates those propositions and certainly doesn't expand them in terms of what the subsequent case law of the Court of Justice has done with Ablesio. Can we, against that background, look please now at City Land, which, my lord, my lady, you should have now in volume 2, tab 38. So I think it's beginning at page 487.
Yes.
So one gathers from paragraph 2, bottom of 487, 488, that this concerned the removal of city land from the VAT register. Paragraph 14, this is part of the Bulgarian law legal context, so this is page 489, refers to Article 176 of the domestic law on VAT, which provided that the competent tax authority may refuse to register a person or may terminate the registration of a person who, 3, persistently fails to comply with his, her, or its obligations under this law. And one sees on page 490 the procedural history relating to a tax inspection, paragraph 17, which led the tax authority, paragraph 18, to find that the company had persistently failed to comply with its obligations by failure to pay various sums by way of VAT. There was a reference in paragraph 20 to the relatively modest amounts involved. One sees from paragraph 22 that the administrative court had doubts whether the domestic legislation providing for the possibility to remove a company if the VAT register was compatible with EU law, insofar as the VAT directive doesn't provide for the option of excluding a taxable person from the VAT system. Paragraph 23, according to the referring court, the Bulgarian legislation doesn't establish an obligation for the competent tax authorities to examine fully the conduct of a taxable person in order to conclude there's a risk to tax revenue and a likelihood of fraud. And one sees in paragraph 25 on page 490 the questions which were referred. And if one then looks at the consideration of those questions, page 491, paragraph 26, refers to the fact that the court was asking, in essence, when the first subparagraph of Article 2131 and Article 273, the principles of legal certainty and proportionality must be interpreted as precluding national legislation which is interpreted by the tax authorities and the national courts, provides the possibility for the competent tax authority to remove a taxable person from the VAT register on the ground of failure to comply with VAT obligations on that taxable person's part, without that tax authority analysing the nature of the infringements committed and the conduct of the taxable person at issue. So that's pointing to what was being considered. If one then goes, please, the same page to paragraph 30, one sees second sentence, it's recorded that although it's possible for a member state to refuse to assign an individual number to a taxable person, it cannot do so without legitimate grounds, and there's reference to Ablesio and to Promexor. Then paragraph 31, there seems to be a possible contrast between that and, as regards, on the other hand, the adoption of measures to remove the VAT identification numbers previously allocated, although in the event nothing, I think, turns on that. Paragraph 34 refers to the case law of the court and the provisions of the VAT directive being to the effect that member states are required to take all legislative and administrative measures appropriate for ensuring collection of all the VAT due on their territory and for preventing fraud. Paragraph 36 again refers to the prevention of fraud, saying...
Sorry, which paragraph?
Paragraph 36.
Okay.
Correct collection of the tax and to prevent fraud. Member states may, where appropriate, provide for the removal of a taxable person from the VAT register. Paragraph 37 refers to member states having the power to choose which penalties seem to them to be appropriate, but paragraph 38 qualifies that by saying they must exercise that power first in accordance with EU law and its general principles, and consequently in accordance with the principles of proportionality and fiscal neutrality. Paragraph 42, so this is bottom of page 492 and on to 493, says in view of the significant role played by the VAT identification number as regards proof of the tax status of the taxable person and the fact that transactions were actually carried out, purchases of goods and recipients of services supplied by a taxable person who's been removed from the VAT register and therefore does not have a valid identification number for VAT purposes will not in particular be certain as to whether they'd be able to demonstrate their entitlement to deduct the input tax, the input VAT paid on that supply of goods or services. Paragraph 45 talks about penalties not being consistent with the principle of proportionality insofar as it's imposed without examining the nature and the degree of seriousness of the infringements committed by the taxable person. And then if one notes again in paragraph 46 a reference to a risk to tax revenue and a likelihood of VAT fraud, and then looks at paragraph 47, that talks about the nature and the extent of any tax fraud committed by that taxable person. Without such a full examination of the conduct of the taxable person, it's impossible to ascertain exactly the nature and the extent of any tax fraud committed by that taxable person, and consequently to assess whether the removal of that taxable person from the register constitutes an appropriate penalty for the purposes for ensuring the collection of all the VAT and combating VAT fraud. So again, that's focusing, we say, on fraud committed by that taxable person. There's another reference.
Those were the facts of this case.
Well, they weren't actually.
Well, in fact, they weren't because there was no such evidence. But
right, but that was the issue in this case. You know?
What do they have standing legislation that said if they didn't have that, be original?
yes, sorry. And in that case, it's the domestic legislation which said that for various infringements of the VAT regime, you could be deregistered, and that didn't necessarily involve any consideration of the wider circumstances, the state of mind of the taxpayer, and so forth.
Right.
Fraud wasn't effectively part of the question referred. The question referred was the validity of the national law which enabled deregistration just for failure to comply with the VAT rules.
And without an assessment of whether there was tax fraud committed by that taxable
So
person.
you rely on this case to say, as I understand it, that the CJU is saying, no, you can't have a general power to deregister. The sort of circumstance where you could deregister would be where that person has committed fraud.
That's in my submission what they're saying. One also gets that from paragraph 50. As I should say, there's also a reference in passing to legal certainty in 49. If one looks at 50, it says, it's paragraph 42 of the which we looked at a moment ago, that a penalty consisting in the removal of a taxable person from the VAT register without formally prohibiting the exercise of a taxable person of the activity subject to VAT, in respect of which that taxable person registered therein is liable to lead to the tax situation. So that's talking again about the inconsistency of that approach with the principle of legal certainty.
Paragraph 46 is a bit wider, isn't it? Legislation
Risk to tax revenue.
Authorities to remove a taxable person from the VAT register without providing for an obligation on the part of those authorities to examine fully the conduct of that taxable person in order to assess whether there is a risk to tax revenue
And the likelihood of
VAT
VAT
fraud. That's not limiting the risk or the VAT fraud to the taxable person. It's a question of looking at the conduct of the taxable person, which is a slightly different question.
But again, it's focusing on the conduct of the taxable person in order to answer the question whether there's a likelihood of tax fraud. Yes, I've already referred to paragraph 47, but if one goes on from 46 to 47, it's all about tax fraud committed, we say, by that taxable person.
I understand your point on 47.
So I think the key paragraphs from this, I think 42, 47 and 50, where we say it's clear that the CJU's analysis in Cityland is clearly focused on fraud that's being committed, if committed at all, by the taxable person concerned, not on others, not on the position of others in the supply chain.
Although equally, you would have to accept that these cases, and I think I'm just not dealing with chains, not dealing with Kittle type situations, are they?
They're not. If I can put it this way, both the Upper Tribunal and my lady in the terms of granted permission recognise that Ablesio doesn't in terms address the position of someone other than someone who is committing fraud.
But Kittle does, and the effect of your case, as I understand it, is that Kittle would permit the denial of input tax deductions on the basis that you should have known that you were participating in the transaction chain where there was some VAT fraud going on at some point in the chain. You would say that's permitted denial of input tax deduction, but you can't go one step further and either register or refuse to or deregister in that situation. So why, can I just put it this way, why if Kittle, which is also can be argued to be a development of the or application of the Halifax principle, permits denial of deduction of input tax, why the difference? Why is it acceptable to deny input tax at potentially great cost in a Kittle situation on the basis of new or should have known, but not to deregister or refuse to register?
Well, the denial of input tax under Kittle is concerned with specific impugned transactions, and its effect relates to those transactions. Deregistration, of course, goes further in its effect, including how its effect is analysed in terms of legal certainty, and isn't limited to a we would say an appropriate and proportionate response to those transactions which are impugned.
But I don't understand the revenue to say that they have a general power to deregister anyone who might be involved in a kittle type transaction chain. They still, as I understand it, they're still saying they would face some level of proportionality test. I know there's a debate about the precise test. But in their letter on the facts of this case, they're saying this, we think this company was mainly used for such chains.
I mentioned legal certainty a moment ago. The other thing which distinguishes deregistration under Ablesio from denial of input tax under Kittle, and it follows from the fact that it's not limited to a response to the specifically impugned transactions, is that it necessarily involves a systematic undermining of the right to deduct in relation to other transactions. And that's something which the CJU repeatedly warned against in the case law.
Well, one of the differences is that it is aimed at preventing that happening in the future in circumstances where Kittle may not actually provide any adequate remedy. The input tax has in fact been deducted and the involvement in the fraud isn't discovered until later, in which recovering the unpaid VAT by denying the input tax is a pipe dream because the company doesn't have the means to pay it. So deregistration is protection for the future in circumstances where Kittle won't always provide an adequate remedy.
But, my lord, yes, of course, its effect is prospective, and one can well see why the revenue would like to have this tool available to it. But we say it goes too far because its effect is systematically to undermine the right to
You
deduct.
say they can never have that as a tool, however proportionate.
Correct. Because its effect is systematically to undermine the right to deduct. In relation to
Even in circumstances where Kittle would say they don't have the right to deduct. How does that work? If the circumstances were that Kittle would enable denial of deduction, how can deregistering infringe the principle of the right to deduct?
Seems to me what you're really getting at is the any untainted transactions. So we're really, this leads you to one's fallback case.
well,
The reason given my
well, the mischief, if you like, of systematically undermining the right to deduct is a mischief in relation to untainted transactions. To the extent that Kittle permits denial of input tax, then there isn't, by virtue of the deregistration, an undermining of the right to deduct, because there is no right.
And what is the difficulty with legal certainty? Let's put it this way. If it is only prospective, cancellation of registration, you know where you are. You know, in reality, you're not going to get input tax deductions.
Well, with respect, my lady, the position's a bit more complicated than that, because how does a trader deal with the possibility that he will exceed the compulsory registration threshold if he continues trading at all. And of course, this isn't said to be at all the legitimate effect of which is to shut down a trader altogether. If there are other tools that can be used for that purpose where appropriate. But a trader doesn't know whether he's going to be served with an assessment further down the line. He doesn't know whether he should carry on trading with the possibility of exceeding the compulsory registration threshold, but given that he's been deregistered, there's not much he can do about it.
Well, I thought the Revenue's answer was if the Revenue have said you are compulsorily deregistered and you're not entitled to be registered, then they're in the position of an unregistered person and they don't charge VAT and they don't account for that. What's the uncertainty about that?
Well, is it subsequently going to be said that although they've been deregistered, because they exceeded the compulsory registration threshold, they were subject to certain obligations, which we looked at when we counted through the domestic legislation earlier in terms of
but they only apply to those who are registered. The Revenue don't say, and it would be very surprising if they did say, though we have compulsorily deregistered you, you must behave as though you are registered.
Yes, as a friend remarks that if you meet or exceed the threshold, then you are registrable rather than registered.
So subject. You would say not subject to the overriding abuse of rights principle, that in circumstances in which Ablesio does apply, you have a right to refuse registration.
It's not, my lord, it's genuinely not clear to us what the Revenue say the consequences are of a trader who's been deregistered under the Ablesio principle if he then exceeds the compulsory registration.
That's a consequence of Ablesio. If there are circumstances, there are Ablesio circumstances, indisputably come within Ablesio, and the Revenue refuse to allow registration, and the trader then makes what would otherwise be a taxable supply in excess of the threshold. But the same situation. Doesn't tell us anything about the scope of the Ablesio principle, does it? And that's just inherent in the Ablesio principle existing at all.
It remains our position that there is a real issue in terms of legal certainty here, and we'd be interested to know what the Revenue's position is in relation to the status of a trader who's been deregistered and who then exceeds the compulsory registration threshold.
I think they've set it out in their skeleton, but we'll hear in due course.
Conscious of the time, if I can just wrap up in relation to what the Upper Tribunal decided, and then move on to our appeal fairly shortly. So at paragraph 35, so that's core bundle 8, page 94. As we saw, it says that the Court of Justice made clear what was necessary in order for a refusal to register to be proportionate, and refer to paragraphs 34 and 38 as we've seen. Paragraph 71, so that's page 102, correctly acknowledged that the decision on Ablesio doesn't address the question of whether the right to refuse registration extends to a person who isn't fraudulent, but who knew or should have known it was facilitating VAT fraud. We'd say that it's reasonable to infer from that because that wasn't a question which the CJU was actually seeking to address. 72 to 98, it set out its reasons for holding at 100 the Ablesio does extend to allow VAT registration of someone who isn't himself fraudulent. And then 109 to 117, it gave its reasons for holding in 111 and 118 the extension, as we've described it, of the Ablesio principle, or the interpretation of the Ablesio principle, so as to permit deregistration of someone who isn't fraudulent, who's making untainted supplies, doesn't systematically undermine the right to deduct, and doesn't contravene general principles of EU law. So far as ground one then is concerned, we say that the principle doesn't allow the deregistration of taxable persons who haven't themselves fraudulently evaded VAT or have the intention to do so. We say that's supported by the language used in Ablesio and by the fact that extending the principle, as you've heard, we say would have the effect of systematically undermining the rights to deduct. And we say that the Upper Tribunal, in holding to the contrary, made an error of law. In particular, at 72, so this is page 102 of tab 8 of the core bundle, the Upper Tribunal stated the abuse of law principle in the VAT context is broad and extends to those who facilitate VAT fraud. As I've said already, abuse isn't a one-size-fits-all concept, and we say that what constitutes an appropriate step to combat abuse must depend on the nature of the abuse, taking into account principles such as fiscal neutrality that are central to the common system of VAT. So as we've mentioned in our skeleton, in Telios, in Feeney H, in Halifax, and in Kittle, certain steps are appropriate.
Sorry to stop you, but you addressed right to deduct and legal certainty, but can I just come back to fiscal neutrality? We've seen through the recital 7, fiscal neutrality is concerned with, like other things, is avoiding distortion of competition. And the evasion of VAT is capable, and I think it's suggested it's the effect of what's happened in this case, but that doesn't matter. It's capable of distorting competition, because if VAT isn't being ultimately charged and accounted for in a chain, it enables the prices to be reduced accordingly. How is fiscal neutrality in some way compromised by the application of the Ablesio principle in the circumstances with which we're concerned in this case?
Well, the deregistration puts the taxable person at a disadvantage vis-a-vis his competitors, because those competitors will be capable of being registered for VAT and therefore in a position to deduct input tax on their purchases.
But equally, allowing registration, which will permit fraudulent VAT evasion, itself will offend the principle of fiscal neutrality. And that's what justifies the application of the abuse of rights principle in the circumstances in which it's proportionate to do so.
My Lord, we say that the reality is that a trader who's deregistered is placed at a significant disadvantage vis-a-vis his competitors, and that of course is in circumstances, or at least on our second analysis, I suppose, in circumstances where there are untainted transactions.
Well, it may or may not. It all depend on the facts. If they're facilitating a £500 million fraud on the revenue by Party B, and they would only be going to have one single untainted supply of 85,000, the overall effect would be of allowing the registration in order to allow that all to take place would be to distort competition.
Then I think
it all depends on the facts.
And we will say then stray into issues of proportionality, which are not easily compatible in terms of preliminary issues. How the trader's business is balanced as between tainted and untainted transactions, I see.
But I think it's your case, on your fallback case, that if the answer to question 1 isn't an absolute, it's only the first limb, one untainted transaction prevents deregistration.
Yes.
And if we're looking prospectively at transactions in the future, either as a result of deregistration or on a pure Ablesio basis of a refusal to register, is it sufficient that there's just the possibility of one untainted transaction unknown at that time? Is that sufficient to prevent Ablesio being capable of being applied?
Hang on, I see the force in that.
What's your case? Is it, the answer is yes?
Our case is, the answer is yes.
Now, we're going to have a break. Would that be a convenient moment? Yes. So what, 5 minutes?
5 minutes.
Thank you.
Did you get a new wig when you were made up? It's just had such little use. Abandoned the criminal bar at such a tender age that it doesn't even have a whiff of fag smoke about it. Roving, the whole thing just
Cloud of smoke.
fog of fag smoke, cigar smoke. And even when they banned it, just lean out of the windows, pretend they were. Just couldn't think of that these days.
No. Remember going into clubs and bars, smoke everywhere. It was brilliant.
Because you could never be accused of having been smoking yourself.
Well, we went into Inferno's after the smoking ban. First thought was, we wish they'd kept it. Actually smell the place. While I'm thinking about smoking. Stay on YouTube. For posterity.
Liza Babel.
Yes.
My lady. I'm just going to refer, if I may, to a few of the points that were made by the Upper Tribunal in its decision, and to flag what we say in response to those.
Yes.
At 74, so this is core bundle tab 8, page 102. The Upper Tribunal stated that the CJU and Ablesio didn't refer to the probability of the number being used fraudulently by that person. We say that that paragraph, our spectral submission, reveals a number of flaws in the Upper Tribunal's reasoning and logic. First, we say it can't be reconciled with the explicit reference in Ablesio at 36 to the taxable person's fraudulent intentions. Secondly, there's no allegation that anyone has fraudulently used impacts VAT registration number. HMRC's allegation is confined to a plea that the appellant knew or should have known about a fraud allegedly perpetrated by someone else, and we've already touched on Citibank. An allegation that someone knew or should have known of fraud perpetrated by someone else in this context isn't an allegation of fraud.
The allegation in the letter is that the dominant purpose in seeking registration in the first place was to enable the VAT fraud to take place. Is that not misuse? An allegation of misuse by impact of its registration number?
My lord, I'm not sure that that's the. I mean, my own friend will correct me. I'm not sure that that's the case as it's presented by the revenue. I know what's said in the letter, but I'm not sure that that is the way in which the revenue now put their case. Sorry, at 75, the Upper Tribunal referred to Ablesio at 36 and acknowledged that the reference there to an intention to commit tax evasion as it put it, does address the position of a fraudster and not a facilitator. But it then went on to say that in the following sentence, the court refers to the taxable person's fraudulent intentions, which is somewhat wider wording. But we respectfully submit that the Upper Tribunal's reasoning there is not easy to follow. But insofar as what it was saying, was that the Court of Justice's reference to the taxable person's fraudulent intentions was sufficiently wide to encompass someone who wasn't himself a fraudster and didn't intend to use his VAT number for fraud. That's inconsistent with the natural meaning of what the Court of Justice said. At 76, there's the reference to misuse of the identification number or other VAT fraud in Ablesio at 38, which we've already touched on. At 77, the Upper Tribunal acknowledged that in answering the question referred to it, the Court of Justice referred to suspicion that the VAT identification number will be used fraudulently and the risk of tax evasion. It said it didn't accept that these are impliedly references only to fraudulent activity by the person to whom the numbers are assigned. We say that if one looks at the Court of Justice's decision as a whole, rather than taking those points in isolation, it's clear, we say, that use of the Ablesio power was confined to circumstances where the VAT registration, which is to be refused or withdrawn, is one which will be used fraudulently. At 78, there's another point made in relation to the language used in Ablesio, but we say the CJA used the language which it did, will be used fraudulently, fraudulent intentions. It didn't regard the principle as extending further to those who didn't behave fraudulently and didn't have fraudulent intentions. At 80, the tribunal referred to the fact that there have been several CJU decisions that have referred with approval to Ablesio, but none have proposed or suggested either of the restrictions contained in ground one. The short answer to that is that in none of the CJU decisions that are referred with approval to Ablesio, had it been proposed that the Court of Justice intended the broader interpretation upheld by the Upper Tribunal. So far from supporting the conclusion reached by the Upper Tribunal, the absence of any reference in the later CJU authorities to what we would describe as an extension of Ablesio to those who knew or should have known tends to suggest that the Court of Justice didn't regard and doesn't regard the principle to be of such extensive reach. And you've got my submissions already on CityLab, which of course postdates the Upper Tribunal's decision. A couple of points I'm going to respond to made in the revenues skeleton. One is the point made in paragraph 5 of the skeleton, core bundle tab 4, page 40, where it said that for the VAT periods where HMRCs refused the appellant the right to deduct based on the Kittle principle, the denied input tax. Forgive me. Tab 4 of the core bundle, page 40, para 5. Point they make there is that in relation to the denial of input tax, the denied input tax is some 97% of the total input tax claimed. The transactions relied on in the deregistration appeal are the same as the transactions in the Kittle appeal. That, of course, is to be expected. So it's said that the assumed factual basis is therefore that the appellant's transactions weren't connected.
Can I ask about assumed factual basis? Because this isn't a sort of strikeout application where you assume the claimant's case. I don't think we can assume any facts, can we?
Well, and my lady, you certainly can't, in my respectful submission, read across from what the revenues say in the Kittle appeal about X number of transactions, which mathematically amounts to X percent of the input tax claim, and say that for the purposes of these preliminary issues, you should assume that is what the transactions were. The reality is that there are preliminary issues decided for the purposes of those issues on an assumption that that impact your should have known. But it's not a case.
Sorry, this can be argued both ways, because one way of doing this is to say okay, we've got no decisions as to the facts, but one could test the correctness of the parties' arguments by reference to what HMRC has asserted as a sort of illustrative set of facts. What would the answers to the questions mean on these facts?
Rather than assuming the truth of those.
Yes, I take it that both parties would agree that that would be acceptable. In other words, you don't assume correctness of facts.
Yes, my lady, that's the shorthand, but it's expressed far better by my lady.
Okay.
So far as this point is concerned, you say that the preliminary issues must be answered in the same way, whether the untainted transactions are 0.0%, 0.05% or 50%. May make a different proportionality on the facts, but
That's not
as a matter of principle, the answer to the questions is the same, however small a drop in the ocean they may be.
I would guess. And in relation to the points made, specifically in relation to ground one in the revenues skeleton, first paragraph 15, prior domestic first instance decisions, that's not something which in my respectful submission is likely to provide very much assistance to this court. Paragraph 17, a point which picks up on what the tribunal said about no CJU judgment seeking to limit the principle on which Ablesio is based. Quite the opposite. It's not clear to us what's meant by quite the opposite, but we're certainly not aware of any judgment applying Ablesio that says that Ablesio applies to those who aren't themselves fraudsters. And City Line, as we've seen, certainly doesn't say that, and that's the most recent decision on the point. Paragraph 18, so this is page 45 of the core bundle, limiting the anti-fraud and abuse principle to those who are themselves fraudsters, as opposed to those who or should have known would run contrary to Kibble and Ital Loader. There's no good reason why the approach in those cases shouldn't also apply to VAT registration. The short answer is that there is a good reason, and it relates to the systematic undermining of the right to deduct, which you've already heard from me, removing as it does the right not only in the tainted transactions, all transactions and on a prospective basis. Paragraph 19, page 45, this picks up on a point which I think my lady put to me. It would be a remarkable result if the fundamental principles of the VAT system permitted refusal of input tax to those who are fraudsters for treated as assisting them, but didn't permit their VAT registrations to be removed simply because they weren't themselves fraudsters. Much the same point can be made as in respect of paragraph 18. A refusal of input tax under the Kittle principle targets specific transactions and doesn't, therefore, we say, risk undermining the right to deduct. Paragraph 20, page 45 to 46 of the core bundle, the restriction proposed by the appellant would mean that even those with a confessed intention of engaging solely in abusive transactions that they knew were connected to fraud would have to be permitted VAT registration, charter for those who facilitate VAT fraud. But that description, in my submission, sounds very much like someone who is fraudulently misusing his VAT number, and so would be caught, we say, by what we say is the proper, more limited scope of the Ablesio principle anyway. And importantly, we say that HMRC aren't toothless here. If what they're really saying is that a particular trader is a fraudster, then they can and should plead and prove that, which a successor would bring them within what we say is the proper scope of the Ablesio principle. And it's only right that if that is really their case, they should plead consistently with the attendant strictures and endeavour to prove that before, to return to my nuclear analogy, before pressing the nuclear button. So far as ground 2 is concerned, you've already heard quite a lot.
Are there some pleadings before the First Tier Tribunal which got that far before the preliminary issues were formulated?
No, I don't think so.
I think we do. Well, we were about to start the case, so there was a statement of case, evidence, and opening as far as I recall, albeit it's in the list of time. And then the preliminary issue arose, and we invited the tribunal, for better or worse, to determine it, because if we were wrong, there was no point in the tribunal taking 3 weeks to go through
So there
10,000
effectively
pages.
were the equivalent of pleadings in terms of your statement of case.
It was a statement of case, and as I recall, it's a written opening, but I can check the dates if that is material. But this wasn't in the ether, my lords, my lady. It's a case about to start. And it may well be that the FTT recorded some of that, but that's as we recall the position. I certainly recall slaving through an opening document, so we were that far. I should say that neither of my other friends were involved at that point, and so that may well be where the discharge is.
I was going to move on to ground two more substantively, but I think the reality is that in relation to our key points on systematically undermining the right to deduct, fiscal neutrality and legal certainty, we've covered most of that ground, I think, in the course of my submissions so far. There is also, as you'll see from the skeleton, reliance on proportionality, especially in light of, I won't say the assumed facts, but the basis of on which these preliminary issues come before the court. We recognise that proportionality alone is perhaps unlikely to be determinative of the case, certainly in our favour, but you'll have seen from what we say in the skeleton that we rely on Lumsden. There's a different test contended for by revenue, and there is some discussion in the Upper Tribunal's decision at paragraph 112, so that's core bundle 8, tab 8, page 109, of alternative measures to deregistration. And the tribunal went on to say that a refusal to register or a deregistration is a measure with more far-reaching implications than other available measures because it's prospective, and that registration is very important in proving VAT's status for VAT purposes. Some counterparties might be less willing to transact with a person without a VAT number. And so, with respect, on a proportionality assessment, the question isn't whether the alternative measure is more far-reaching, but rather whether it achieves the relevant objective. And we say the relevant objective here must be ensuring that the VAT system is properly operated, which, as well as preventing abuse, involves ensuring the correct application of the central tenets of that system, including fiscal neutrality and the right to deduct. And that objective isn't advanced, certainly not in the least onerous way, by, as the Upper Tribunal seems to suggest, inhibited legitimate trading by making a given trader appear to be a less attractive commercial counterparty. My lords, my lady, would you bear with me for just a moment? Unless there's any further assistance I can provide at this stage, those are our submissions.
No, thank you very much. Yes, Mr. Watkinson.
My lord, my lady, just this matter's being raised, I've slightly refreshed my memory. There was a hearing, 10 days length, listed for the 20th of April of 2020. No doubt if we all cast our minds back to that time, we'll know what was happening. There was therefore logistical issues about whether the hearing could go ahead. It was after that that this was raised as a preliminary issue. So we were at the advanced stage or in the litigation of pleadings exchanged, witness statements exchanged, HMRC's opening submission. They did not detract from what was said in the letter. The proceedings carried out on the same basis. Can I make two preparatory observations, please?
Sorry, you said they were basically consistent with the letter.
Yes.
But the allegation is a know or should have known rather
Precisely.
than alleging fraud or
Precisely.
dishonesty.
So to be clear, the allegation is knew or should have known to justify both the input tax denial of £47 million and the refusal of registration. One prefatory observation on the nature of the legal issue. The court understands this is only a preliminary issue, and therefore, as the Upper Tribunal remarked, it must be the appellant's argument that it is, as a matter of principle, never possible to deregister a trader who, for shorthand, I'll say, has the Kittel state of knowledge, i.e. knew or should have known that their transactions were connected with the fraudulent evasion of VAT, or would undertake such transactions in the future by reference to risk. Secondly, it's never possible as a matter of principle to deregister someone who has undertaken a single untainted supply or who may possibly undertake such a single untainted supply in the future, because this systematically undermines the right to deduct. The second prefatory observation, if I might, my lords, my lady, is as to the nature of the wider underlying issue, and that is orchestrated VAT fraud and its prevention. Of course, if a trader is one of the vast majority of taxpayers who does not get involved in transaction chains connected with the fraudulent evasion of VAT, let alone knowingly so, has absolutely nothing to fear from the principle upheld by the Upper Tribunal. And it was the scale and nature of that type of fraud that led the CJEU to develop the principle in Kittel. Can I invite my lords, my ladies, to go to the Authorities Bundle, Volume 1, Tab 23, page 55, please.
Sorry, can you give me that again?
Yes, my lord. Volume 1, Tab 23, page 55.
Thank you.
Mobilex, Lord Justice Moses, as he then was. Key case in this court on the application of Kittel that sets out the background at the bottom of page 55, paragraph 1. His Lordship records some of the factual backgrounds of a particular type of VAT fraud, MTIC fraud, in that instance using mobile telephones and computer chips, and cited Lord Hogan's Total Network, who described this type of fraud as a sophisticated attack on the VAT system, a pernicious stratagem, and was of the view that member states were justified in making use of every means at their disposal within the scope of the 6th Directive to eradicate it. The facts of two of the appeals before Lord Justice Moses are perhaps illustrative of the potential problem. One goes over to page 56, please. Paragraph 56.
Sorry, do you mean paragraph 6?
Paragraph 6, forgive me, my lady. Bottom of page 56. The facts in Calltel and Opto. Millions of pounds of reclaimed each month. Part of transactions that were nothing more than a device by which the tax authorities could be cheated. Paragraph 8. G. Paradigm case where the traders knew of the connection between the transactions in which they were involved. VAT fraud. And the effect of the appellant's position is we submit stark. There's nothing HMRC can do about the actual VAT registration of such a trader.
Well, you would say the only thing that you could do is try to bolt the door after the horses.
Yes. It's a phrase that I'm going to come to. My lady's read my mind, as ever ahead of where I'm going. But the effect of the appellant's argument is HMRC can deny these people the right to deduct ex post facto. The tax isn't in HMRC's hands, they can try to recover it. But my Lord Justice Popplewell described it as a pipe dream. It's well known that it's largely fruitless exercise to go after these types of traders, if I can use such loose language, save in exceptional cases. No one's pretending here that the sort of £47 million worth of money is paying revenue, for example. Of course, the more sophisticated VAT frauds were those of a carousel nature. Again, the effect of the appellant's argument is HMRC can break one spoke, that is the defaulting trader. The rest of it has to be left intact. The obvious risk that the spoke is simply replaced in the bicycle shop and the wheel remade. As is well known, VAT fraud is not confined simply to computer chips and mobile telephones. It has an element of whack-a-mole to it. So once it's dealt with in one trade sector, it pops up in another. So carbon credits, Citibank, the Tower Bridge, the metals industry, and now the labour market. These forms or structures are bounded only by the architecture of the VAT system and the imagination of those who devise such schemes. The point of these observations, my lord, my lady, is that orchestrated frauds of this nature rarely, if ever, rely solely on the entity that fraudulently defaults on the VAT. They rely on other entities entering into the transaction chains, many of whom know exactly what they're doing in terms of knowledge, even though it's not their, in a strict sense, VAT number that's being used for fraud. It's not their VAT obligation that may be being defaulted upon directly. And there are others who should have known that the only reasonable explanation was fraudulent evasion of VAT. And then my Lady Justice Falk's point, what usually happens, by design, the actual defaulting party pockets the VAT, disappears, the horse has bolted in terms of that. So one can see, I hope, immediately the type of difficulties that produces for HMRC in its care and management of the VAT system. The effect is, even if one has proved in the tribunal that the trader knew millions of pounds of its transactions were connected with fraudulent evasion of VAT, they must be permitted to remain within the VAT system to do as they please, and HMRC must clean up the fraud only after the event. In our submission, that is apt to only foster and encourage, and not to prevent, VAT fraud, the latter being a fundamental objective of the system. The Upper Tribunal recognised in our submission correctly the risk of creating charters, both for fraudsters, so those who undertake £10 million of fraudulent transactions themselves, but £1 of clean transactions, and for those who facilitate fraud. Our overarching submission, my lord, my lady, is that the Upper Tribunal was correct in its conclusions, summarised in our skeleton argument of paragraph 3, for the cogent reasons that it gave, summarised at paragraph 120 of its judgment. The principle in Ablesio is not limited to the actual trader directly fraudulently evading the VAT, but rather can be applied to enable the deregistration of a person who has facilitated the VAT fraud or of another, or will in probability do so, where it knew or should have known that. Secondly, we submit that the principle can be applied, notwithstanding that the person whom HMRC seek to deregister made or potentially will make an untainted supply, even if that causes them to go above the liability threshold in paragraph 1.1 of Schedule 1 to that.
And HMRC, just to clarify a point.
Yes. So the HMRC's position is clear. If you've been deregistered, as per the very recent addition to the authorities bundle, you cannot charge output tax. There's a penalty provision that permits that,
Is it
which
appropriate
is,
to take us to that?
yes, it's the very last page of the authorities bundle, my lady, page 495, tab 39 in the second bundle. That is Schedule 41 of the Finance Act 2008, paragraph 2, which has been enforced since the 1st of April 2010. My lady will see its penalty provision, subparagraph 2. Subparagraph 1, firstly, penalties payable where a person makes an unauthorised issue of an invoice showing VAT. Subparagraph 2 then defines that unauthorised person thereafter defined at 3A. Anyone other than a person registered under VATA. If you're not on the VAT register, you cannot issue an invoice showing an amount as being VAT. So the position we submit in terms of the deregistered trader and its own supplies onwards is clear. It's forbidden by this provision. In terms of the customer who's receiving that, he will know. Number one, you shouldn't be doing this. Number two, you don't have a valid VAT number, so I haven't got a valid VAT invoice. Couldn't be any question that such a trader thought it had the right to deduct in our submission. Going backwards in the supply chain, it's also clear we submit that the deregistered trader has no ability to exercise any right to deduct. Doesn't have any VAT number, can't make any VAT return, can't reclaim any input tax. In the same way as any unregistered trader. With that we submit is clear. In terms of the threshold issue that my learned friend raised, it applies in the ordinary way. So if you are deregistered but you exceed the threshold, you need to notify HMRC. And HMRC can then determine in the ordinary way whether to register you, doubtless cognizant of the fact of the basis for your previous deregistration.
Okay, so you do accept, because those provisions are not switched off, but the obligation to inform HMRC if you do trade, well, in theory you should have to inform them straight away, because one of the bases is you've had supplies in excess of the threshold over the last 12 months.
Yes, it would depend on whether there's any temporal dislocation.
Yeah.
But the thrust of it is, if you're going to exceed the threshold, you need to notify HMRC, that's the obligation, and they can then make their decision in the ordinary way. So that is as far as goes in our submission, and there's no lack of clarity as to it. You have the summary of our submissions on ground 1 in paragraph 7, skeleton. We do submit that a helpful starting point may be to consider, as we've set out thereafter, firstly the genesis of the anti-fraud and anti-abuse principle, how it works, where Ablesio sits within that, and then secondly, the CJEU case law on the scope of that principle. And that is because the effect of the appellant's argument must be, for example, that deregistering even those who only ever participated in transactions that they knew were connected with the fraudulent evasion of VAT is outside the scope of that principle. Unnecessarily so. And so once one's examined the scope of the principle and how it works, we submit that may assist in assessing whether the appellant's argument is correct. The Upper Tribunal noted, as we've recorded at paragraph 8 of the skeleton, paragraph 23 and 80 to 81, that issues relating to the scope of the Ablesio principle must be considered in the context of general EU law on the prohibition of abusive practices in relation to VAT, since Ablesio concerned the application of that general law to the particular situation of registration for VAT. We understand it, the appellant does not take issue necessarily with that as a starting point. We make two broad points as to that, my lords, my lady. Firstly, insofar as the Ablesio decision sets out a principle, we submit that it is only an expression of a fundamental principle that already existed. That is the broad anti-fraud and anti-abuse principle of EU law that prevents such law from being used for fraudulent or abusive purposes.
Well, you say that fits with Ablesio being issued, the judgment in Ablesio coming out without an Advocate General's opinion.
My lady, that was the next line in my,
Sorry,
in my notes.
I should shut up.
No, you
My
shouldn't, my
voice
lady.
is telling me to do anyway.
Done it again, my lady. Secondly, the Upper Tribunal observed at paragraph 82 that the judgment was issued without an AG's opinion. That is indicative that the court did not consider that it was either breaking new ground or setting any new point of principle, but rather it was applying a fundamental principle that already existed. That may be important, because in our submission it points away from the CJEU deciding to limit the scope of the broad anti-fraud and abuse principle so that it only applied to fraudsters themselves. And we submit that by that point in the line of authorities, to do so would have been a radical restriction on the scope of the existing principle and represent a significant departure. We submit that the line of CJ or EU authorities shows that the anti-fraud and anti-abuse principle firstly applies irrespective of the VAT right affected by the fraud. Secondly, applies generally both to those who are themselves fraudulently and directly evading VAT and those who knew or should have known their transactions were connected with such fraudulent evasion.
Yes, so you really need to persuade us that the knew or should have known, which only appears in the Kittle line of authority, is of broader application.
Yes, and that's what I propose to do, my lady.
That seems to be an absolute key point.
Yes, that's what I propose to do by going through the genesis of the principles to Ital Moda. So if I can start with Halifax, please. The CJEU referred to Halifax in Ablesio itself at paragraph 28. The Upper Tribunal recognised at 24 that Ablesio stemmed from that wider principle. You can go to the judgment, please. It's in volume 2 of your authority bundle. Tab 30, we can pick it up at 305. That's the start of the judgment. And then 312. Paragraph 58 to 59. This is developing that principle. So the criteria for supplies of goods or services and an economic activity are not satisfied where tax is evaded, for example, by untruthful tax returns or issuing invoices. And then go over the page, please, to paragraph 68. Must be borne in mind that according to settled case law, community law cannot be relied on for abusive or fraudulent ends. 69. Transactions carried out not in the context of normal commercial operations, but solely for the purpose of wrongfully obtaining advantages provided for by community law. Paragraph 70. The principle also applies to the sphere of VAT. And that is because paragraph 71, preventing possible tax evasion, avoidance and abuse, is an objective recognised and encouraged by the then 6th Directive. Paragraph 74 to 75 over the page, the conditions for the abuse principle set out. As the upper
So, it's 74 and 75,
Yes.
which is the what people classically think of as the Halifax principle. You're not relying on so directly here, are you?
No, simply the genesis of the principle that EU law can't be relied on for abusive or fraudulent ends. In
But
Halifax,
your focus is really on the fraudulent use for fraudulent ends, isn't
yes.
it? Rather than the specific tests in 74 and 75.
Yes. So one's not applying this as an abuse case because you've created a commercial transaction that has some other purpose that's just tax avoidance, that kind of issue. So the Upper Tribunal recognised at paragraphs 27 and 72 that the abuse principle itself is of wide application and applies regardless of any specific provision. The next step then is Kittel, which came hot on the heels of this, and the judgment is barely 5 months later. We go also in volume 2 to tab 31, page 342, please. Yes, please, my lord. Paragraph 53 at the top. Court cites Halifax. And 54, preventing tax evasion, avoidance and abuse is an objective recognised and encouraged by the 6th Directive. 55, where the tax authorities find that the right to deduct has been exercised fraudulently, they can claim repayment of the deducted sums retroactively. And then 56 is the extension. In the same way, a taxable person who knew or should have known that by its purchase he was taking part in a transaction connected with fraudulent evasion of VAT must, for the purposes of the 6th Directive, be regarded as a participant in that fraud, irrespective of whether or not he profited. 57, that is, because in such a situation the taxable person aids the perpetrators of the fraud and becomes their accomplice. 58, in addition, such an interpretation, by making it more difficult to carry out fraudulent transactions, is apt to prevent them. Hence 59, even if the transaction meets the objective criteria, one can refuse the right to deduct. And the person who knows or should have known is treated in the same way. My learned friend's submissions sought to drive a wedge between them that someone who knew would be caught by Ablesio if his first ground fails, but someone who should have known wouldn't. The court treats them in exactly the same way here. As the Upper Tribunal recorded at paragraph 84, the rationale for extending the principle to a facilitator of fraud was that such a person must be regarded as a participant who aids the perpetrators, becomes their accomplice. That interpretation makes it more difficult to carry out fraudulent transactions and therefore is apt to prevent them. That is why one's not required to prove dishonesty against someone who's been denied the right to deduct based on Kittel. We submit that that rationale is of wider application to the VAT system. If that's right, it's contrary to the appellant's assertion that Ablesio applies only to VAT fraudsters to the salary. We submit that the Upper Tribunal's first step of applying this rationale to the issue of VAT registration, paragraphs 85 to 86, for the reasons it gave, was correct. It's addressing future abuse or fraud within the VAT system. It is apt to prevent such fraud, which is an objective recognised and encouraged by the Principal VAT Directive. The appellant's proposed restriction is that someone who has the Kittel state of knowledge is treated as a participant in the fraud and becomes their accomplice, can't be registered. The Ablesio judgment follows after that in the chronology. The following year we have Schoenenport. I can invite the court to go to that. That's in volume 2 of the authorities bundle, tab 34. Begins at page 386 with.
Sorry, this post-dates Ablesio, doesn't it?
Yes, this post-dates Ablesio. So Ablesio is 14th of March 2013. This is the following year. And it is we submit an important case on the scope of the abuse principle, how it operates, and how it operates even if you satisfy the provisions apparently giving rise to a right under the VAT system. The key facts, just for your note, my lord, my lady, are in the judgment, page 406, paras 9 to 11. Schoenenport was a shoe trader and ended up trading in electronic goods. And it was refused an exemption from and deduction of refund of that on the ground that it had participated in evasion by its customers who were in Italy. You have the opinion of Advocate General, I'll try to pronounce it, Spoonar, I think, which is helpful because the court picks up on it in its judgment. Paragraphs 1 to 2 set out the backdrop against which the issue is being considered. Fraud.
1 and 2 of the opinion.
Yes.
Yep, got it.
1 and 2 deal with that. One can note that 31 onwards, page 393 to 38, they deal with various descriptions of missing trader fraud.
Sorry, we're still in the AG opinion.
We're still in the AG's opinion, just to give you the framework of it.
Sorry, what was the paragraph again?
Paragraphs 31 to
Yes,
38,
thank
they
you.
deal with the description of missing trader fraud, but I don't invite you to read through it slavishly now.
Yeah.
36 to 37, the AG deals with the orchestrated nature of the frauds. 40, Halifax. 42, then Patel. 43, how that applies to what we would domestically call zero rating. And if one goes on to page 397, please, paragraph 46, the Advocate General develops this notion of the good faith of the taxable person as a general principle in respect of VAT. That equates, one notes at 47, someone who knew or should have known, effectively. Paragraph 49 on the same page, principles applied to what we would call zero rating. Then at 50, in my view, the same should hold for the other rights stemming from the VAT system, and examples are given. At the end of that paragraph, there's therefore no need to distinguish between the right of deduction and the right of exemption on the one hand and the other rights on the other. Over the page, paragraph 51, please. 6 lines down, the sentence beginning, however, neutrality of tax may not be reasonably relied upon by taxable persons who have wilfully or through negligence participated in fraud. So one can't say, well, I'm caught by the principle in Cattell or the principle in Ablesio, whatever its scope might be, as this court will determine, and therefore make a plea to fiscal neutrality. We'll see that picked up in the judgment. 52, forgive me, at the end of that paragraph, then, consequently, I cannot see any objective difference from this point of view between the different rights stemming from the mechanisms of the VAT system, such as the right of deduction, exemption, or refund. 52. This principle is therefore intended to be applicable not only to the right of deduction and the right of exemption, but also to other rights existing in the VAT system and to the right to the refund of any tax paid pertaining to those rights. One then goes over page 399, please, paragraph 60 at the bottom, and we come on to look at city land. This line may be important. Refusal to grant the rights stemming from the VAT system in the case where a taxable person is involved in fraud is not a penalty. So we submit that it is clear that the Advocate General is firstly treating the rights under the VAT system all in the same way, as all being subject to the broad fraud and anti-abuse principle. And secondly, concluding that the principle applies both to those who fraudulently and directly evade the VAT and those with the state of Cattell knowledge. Just before the short adjournment, can I invite the court to follow the opinion into what the CJU itself said? We go on to page 410, please. That's now within the judgment. Just at the bottom of the preceding page, this is where the court begins to consider the first question. Paragraph 42, recitation, preventing possible tax evasion, avoidance of abuses, and objective recognised and encouraged by the then 6th directive. 43, EU law can't be relied on by individuals for abusive or fraudulent ends. 44, right to deduct can be denied. It's shown on objective evidence that it's being relied on for fraudulent or abusive ends. 45, it applies to what we would call zero rating. 46, picking up what the AG had said in his opinion, insofar as any refusal of a right under the directive reflects the general principle that no one may benefit from the rights stemming from the union's legal system for abusive or fraudulent ends. Such a refusal is the responsibility in general of the national authorities and courts, irrespective of the VAT right affected by the fraud. That we submit is important. It's an extension of or clarification that the abuse principle and anti-fraud principle is not limited to the right to deduct, the right to zero rate, if one can call that a right. It's wider than that. 47 picks up on what the Advocate General had said about fiscal neutrality. That conclusion can't be called into question by the fact that this provision constitutes a corrective mechanism designed to ensure the neutrality of VAT. (49) It is in principle the responsibility of the national authorities, etc.
Sorry, can I make sure
Forgive
I've
me.
understood 47?
Yes.
The reference to the corrective mechanism is the anti-abuse principle?
is the corrective mechanism the court's considering there is deduction and refund and deduction. So 0 rating and claiming the input tax. So it has sold to Italy, 0 rated the transaction, claimed the linked input tax. So that is what they're describing as the corrective mechanism. So it's a particular expression of fiscal neutrality so that you're not bearing any other VAT burden than someone else would. Paragraph 49, it's the responsibility of the national authorities and courts to refuse the benefit of the rights laid down by the 6th Directive when they're claimed fraudulently or abusively, irrespective of whether those rights are rights to a deduction, etc., as an issue in C50 for good measure. That's the position not only where tax evasion is being carried out by the taxable person itself, but also where the taxable person knew or should have known by the transaction concerned it was participating in a transaction involving evasion of VAT carried out by the supplier or by another trader acting upstream or downstream. And it goes over then paragraphs 54 and 55, please. Even if there are no national provisions, that doesn't prevent then the state national authority from refusing a benefit derived from a right laid down by the 6th Directive in the event of fraud. (56), please. That refusal addresses the principle that rules of EU law can't be relied on for abusive or fraudulent ends. 57. The refusal of a benefit does not amount to imposing an obligation, merely a consequence of finding that the objective conditions required for obtaining the advantage sought have not been satisfied. That's explained in paragraph 58. You've not met the objective criteria for granting of a right. 59. One doesn't need express legislation for the national authorities and courts to be able to refuse a benefit under the common system of VAT. That consequence must be regarded as being inherent in the system. 60. If you've created the conditions for obtaining the right only by participating in fraudulent transactions, you can't invoke legal certainty. 61. Such a refusal is not in the nature of a penalty or a sanction. And then 64. Not only the situation in which tax evasion is directly committed by the taxable person himself, but also the situation in which a taxable person knew or should have known that through the transaction concerned it was participating in a transaction involving evasion of VAT is considered to constitute fraudulent conduct on the part of a taxable person, which may give rise, in regard to that person, to a refusal of a right laid down by the 6th Directive. And then 66, it's irrelevant whether solely by reference to your domestic conditions you've met the criteria for such a right. And so, very shortly, that judgment is, in our submission, a powerful statement of the scope and breadth of application of the principle, and we rely on it for the following propositions. The anti-fraud and anti-abuse principle applies irrespective of the VAT right affected by the fraud, all rights and benefits under the system. Paragraph 46. Applies in general both to those who are themselves fraudulently evading VAT and those with the Cattell state of knowledge. Paragraphs 50 and 64. The principle works in the following way. even if you prima facie satisfy the criteria for a right, benefit or advantage, whether under the PVD or domestic legislation, if you're acting fraudulently or abusively, the right doesn't arise. If you have a curtailed state of knowledge, the right doesn't arise. Paragraphs 58 and 59. If you fall within the principle, you can't invoke legal certainty to prevent it applying. Paragraph 60. Finally, paragraph 68. Any other interpretation would not comply with the objective of preventing tax evasion as recognised and encouraged by the 6th Directive. If the expression of the Ablesio principle is confined solely to the fraudster himself, acting as fraudster, the way the court treated the general anti-fraud and abuse principle in Sherman Court would be wrong.
So, would you describe being registered as the right, or what goes with it?
It's at least a benefit or advantage. So hence what my learned friend took you to in Cityland about the advantage of having a VAT registration. It's an ordinary badge of trade, and when you don't have one, someone will ask why. One can read it as a right in a certain way, in that if one's liable, one has to say to HMRC, well, I've exceeded the threshold, ordinarily you should register me. And one can describe it as that way, but it's certainly at the least an advantage or a benefit under the VAT system. Indeed, that's the very reason why this appellant is here. It says deprived of that advantage or benefit, and my learned friend has said in terms, one of the benefits of being VAT registered is you can then deduct input tax. So I've slightly overrun, which I apologise, but I thought it might be better to finish that. So
2 o'clock?